Hey everyone, it's Rob Ryder. It's February 15th, 2017, and it's been a while since I've done a video, so it may take me a minute to get into this. But what I wanted to do was share some information I got on non-judicial foreclosures by actually looking at the paperwork, which I had never really seen how they did a non-judicial foreclosure before. Somebody sent me the letter, and it's like, well, hey, it says some pretty interesting things. And then after that, we'll talk a bit about what has happened with a couple of different guys who actually sent letters to the chief judge in their court case, complaining that what was going on in the courtroom was a violation of their civil liberties or protections of the Bill of Rights or whatever people need to say to make themselves feel comfortable. And then what the judges did and where it stands today. And basically it's, well, they're waiting for us to do something, it appears. So, but that's after this. So first, non-judicial foreclosures and what the judges, and then what the judges said. My phone number, again, I'm Rob Ryder. My email address is courtofrecord@aol.com. My phone number is 616-712-6179. My email address has no S's in it. It's not courts of record, and it's not court of records. It's court of record. Put no S's, or I won't get it. And I have to ask if you can donate, that you please do. It's really how I do what I do, and the coffers are quite low. So any help is greatly appreciated. PayPal account, well, that's my daughter's name. That's the PayPal account. Name is ashleyrytlewski@gmail.com. ASHLEYRYTLEWSKI@gmail.com. Greenville, Michigan has a Walmart and a Myers. Go figure. Myers is Western Union, and Walmart is, well, whatever Walmart uses. But there's another way to do it. And then you'd have to send me an email at courtofrecord@aol.com to tell me that you had. And then there's always the mail. Robert Rytlewski, 10955, 14 Mile Road Northeast, Rockford, Michigan, 49341. Yes, my name is not Rob Ryder. It's an avatar. Trying to say Robert Allen Rytlewski all the time to people is, after 60 years, it got to be a bit difficult. Yeah, a long time ago. So, hey, Rob Ryder, that's who I am. And I wanted to point out two things that were going to come into play at some point, and what we're talking about, because the Seventh Amendment to the Bill of Rights, or in the Bill of Rights, says in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be reserved, and no fact tried by jury shall be otherwise reexamined in any court of the United States than according to the rules of the common law. And if you look at how people are being charged, they're actually being charged criminally with a common law offense, a word offense like burglary, or disorderly conduct, or against the peace and dignity of the state. Things like this, right? That's a common law offense. It's not a statute number, like, some statute number for whatever the criminal code violation is you're supposed to have done. And so when you really look at the papers, you'll see they're not actually charging you with a statute. They're charging you with a common law offense. Well, that means if it has a value greater than $20, you have to have a jury. So I would say, well, who do I pay the $20 to? Say, Judge, there's no jury here, so this must be a controversy less than $20. Not that we have to want to use that. I'm just saying that's what's happening, right? That they're using common law in courts, pretending that it's statute law, because they don't have any jurisdiction in statute law. At the state level, these courts are at best a local court, and they have jurisdiction maybe in ordinances, but not in the state law. But they would have jurisdiction in common law at the same time. So, because here's a very good example. In Alabama, in Section 170 of their Constitution, it says style of all process. Well, that would mean if you're going to court, in a state court, the process shall be the state of Alabama. And all prosecutions shall be carried on in the name and authority of the same, and shall conclude against the peace and dignity of the state. There's that common law addition. To anything that they do, it's going to also say, and shall conclude against the peace and dignity of the state. But the important thing is here, it says the state of Alabama. If you're involved in any kind of case in Alabama and it doesn't say the state of Alabama, well, then they're not following the Constitution. That'd be a violation of your civil liberties protected by the Constitution. Right? So I'm just saying. In fact, I looked at a court. The reason I know this, I was looking at somebody's case where their son is in prison, and it says state of Alabama. It doesn't say the state of Alabama. And yes, it makes all the difference in the world. One is the de jure state that has the constitutional authority, and the other one's a usurper pretending to be the state that has the constitutional authority. And we need to point out the usurpation of the constitutions. And that's the idea of writing to the chief judge to say, hey, I don't know if you know what's going on. Apparently not, but they're violating my civil liberties down in the courtroom. So that'll all play itself out in a second. But for now, let's go look at... Okay, I got this letter from Jeff. I don't know, about 3 weeks ago, I guess. And they were going to have a foreclosure sale on his house, and he had run out of ideas. His last idea was going to be file for bankruptcy. And then at the last minute, they changed the sale date, so it took the pressure off. At the time, it was like, has to be done now type stuff. So what are we going to do right now, right? That was the idea. Well, so if you're in a non-foreclosure state, you're not going to get court paperwork. Apparently, you get something like this from a attorney and counselor at law. And he says, via certified mail, return receipt requested, copy via regular mail. And it says notice of acceleration of foreclosure. Some file number. So someplace there's a file, right? There's a jacket with a file number on it. And then there's all the papers. And that would be really good to know where that is because we would like a copy of it. And the loan was the note and security deed for Jeffrey to Bank of America, N.A., original lender. Now, one of the many things I saw as I went through this, that Bank of America, N.A. isn't a bank, it's a national association. They couldn't lend you anything. They're an association. It's not a bank that's authorized to lend. And one of the things that, if you follow me long enough, I'm telling you, man, these people didn't sign the paperwork. They never lent you any money. For there to be a contract, it has to be legal. And all legal documents require everybody to use their legal name. And they're not doing that. They're using legal fictions. And then they're not signing the paperwork, which is another requirement of a business contract. Now, some people might argue, but it's up to you. It's it's a meeting of the minds. If I say we both have to sign it, then we both have to sign it. I don't really care what you say. And I say we both have to sign the agreement. If we didn't, then I guess we made a mistake and there is no agreement. So give me back my securities. I don't want to do business with you. And that was all about trying to get our property back, which we're still doing. But that's for another day, right? Today it's just about, hey, this guy is in a foreclosure. So what does the letter say? It says, please be advised that this law firm represents M&T Bank. They would be the foreclosing entity. Successor in interest to the original lender of the above referenced loan. Now, I don't see where they ever said a loan, but the loan number must be somewhere in here, right? 1, 2, 3, 4, 5, 6. That's only 8 digits. I think that they're usually 10-digit numbers. But anyways, above referenced loan. So I don't really see where they ever referenced the loan. But by separate communication, you may have been advised of your rights under the Fair Debt Collection Practices Act. Should that act apply to this proceeding, nothing in this letter shall prevent you from exercising those rights set forth in this communication, or in that communication. This letter is to advise you that we are hereby instituting non-judicial foreclosure proceedings against the referenced property. Enclosed, you will find a copy of the notice of sale under power that was submitted for publication in the legal newspaper in the county where the property is located. The foreclosure sale is scheduled for February 7th, 2017. So sometime between February 1st and the 7th is the first time I'd ever seen this thing. And now Jeff has gotten it backed up, so he's got some time. But it doesn't change what they said. At some point, if you're in Georgia and they're going to do a notice of acceleration and foreclosure, you may get a letter like this. If you're in any other non-judicial state, apparently they're going to send you a letter from an attorney firm. Let's go on. The entire amount of the debt secured by said note and security deed has now been declared due and payable because of, among other possible defaults, failure to pay the indebtedness as and when due in a manner specified in the note and security deed. The total amount of the debt owed may consist of unpaid principal balance, any unpaid accrued interest, escrow, impound shortages or credits, late charges, legal fees, costs, and other charges. To find out the amount you need to bring the loan current or to pay the loan in full, please call, they give a number. Okay. So the entire amount of the debt secured by the note security deed has now been declared due. So what are they trying to collect on? The debt that is due based on the note security deed. It just doesn't happen to have anything to do with the loan. Because here's what it says. Please be advised that the foreclosing entity, that would be M&T Bank, M&T? Foreclosing entity, M&T Bank, intends to enforce the provisions of said note and security deed relative to payment of attorney's fees. I'll read that again. Please be advised the foreclosing entity intends to enforce the provisions of said note security deed relative to payment of attorney fees. They're only after the attorney's fees. Pay the damn attorney's fees. If there are any, right? They're not foreclosing on you. They want the attorney fees. They're going to sell the house because you haven't paid the attorney's fees, so they're going to sell your property to take care of the fee. That's the way this shit works. Right? It's like bankruptcy. Bankruptcy just means you won't pay your debts. It doesn't mean you're insolvent. It means you won't pay your debts. So we're going to sell your property and pay your debts. What they don't tell you is, well, here's the rest of what was left after we paid the debts. That's supposed to come back to you. They never tell you what your debts were, who the creditors were. Kind of a side issue, but they all fit together. It's all the same, scheme. But this says they're foreclosing relative to payment of attorney fees. Unless the full amount owed on this loan is paid within 10 days of the date of receipt of this letter, reasonable attorney fees, as defined in the Official Code of Georgia annotated section, will also be owed. Well, it could be that all that's owed. Because that's all they're trying to collect on is their attorney's fees. Right? So we're going to have to look at this law here. This is some Georgia law. And please be further advised that from this point forward, strict compliance with the current terms of the loan will be required pursuant to some other law. In some circumstances, state law or foreclosing entity may allow default to the loan to be cured and stopping the foreclosure prior to sale date. You may contact this office to find out how to reinstate the loan. Will be allowed, and if allowed, the specific amount will be necessary to fully cure the default. Please be advised that if the default is allowed to be cured and the loan payment must be made in form of cash, cashier's check. So, you could go pay all of it, whatever the default is, but that isn't what they're asking for. They're only foreclosing on the payment of attorney's fees. We do not believe you've been represented by counsel. If you're in the military, we're not supposed to be able to foreclose on you. This notice is not intended to collect a debt against you personally or indicate that you are personally liable for this debt. It had nothing to do with you. However, right, if somebody doesn't pay the attorney fees, they're going to foreclose on the property. This notice relates solely to enforcement of rights with respect to the above referenced property. This property, or this letter, is notice to the extent the federal debt. Is that what that is? Federal? Whatever FDCPA stands for. Nothing contained herein or in future shall be deemed as mission, and that the FDCPA applies to this firm's representation of the foreclosing entity. Right? So it don't have a damn thing to do with FDCPA. Information relative to loss mitigation options to save in your home for foreclosure can be found at, and I want you to go look at their website, contact them, we'll take you down the path we got set up, and hey, we'll either take your property or take all your money. It doesn't matter to them. So, by virtue, notice power sale. By virtue, a power sale contained in that certain security deed from Jeffrey to Bank of America, N.A., recorded somewhere in a county, and security deed having been given to secure note of even date in the original principal amount of $127,207 with interest thereon as provided for therein, said security deed having been last sold, assigned, and transferred to M&T Bank, who has the security deed. It was last sold, assigned, and transferred to M&T Bank. They have the security deed. That'll be important in a minute. There will be sold at public outcry to the highest bidder for cash at the courthouse within legal hours on sale of first Tuesday. All property described in security deed, including but not limited to the following described property. And a legal description. Is it proper or not? I don't really know. But that's what they're selling, is that legal description. So if you had the real legal description, you could say, well, that isn't my property. You can go ahead and sell it. It isn't mine. This isn't correct. Right? This could be really close to being proper, but not be. Said legal description being controlling, however, the property is more commonly known as 523 Emily Drive. And here is 523 Emily Drive spelt out. Here is 523 Emily DR with the city and state behind it. Right, this is coming off of a plat map someplace. This legal description. And this is apparently the commonly known as. So, the indebtedness secured by said security deed has been and is hereby declared due because of default under the terms of the security deed note. The indebtedness remaining in default, the sale will be made for the purpose of paying the same, all expenses of, including attorney's fees, notice to collect same having been given, and all other payment provided under the terms of the security deed note. But that isn't what they said. They said up here that it's only for one reason, right? Be advised, a foreclosing entity intends to enforce the provisions of said note and security deed relative to payment of attorney fees. So somebody else wants theirs, they'd have to do it separately, apparently. Sold as is, where is, or as is, basis without representation, warranty, yada, 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 to the best knowledge, belief, undersigned, the owner and party in possession of the property is uppercase Jeffrey or tenants. It's because they never entitled it to Jeffrey in his full legal name. It's in some kind of legal fiction that has his name in it, but it could say Jeffrey, middle name, last name, husband, and lady, first name, middle name, last name, wife, right? Some kind of legal fiction. They don't put it in your proper name. The sale will be conducted subject to, right? So the sale will be conducted subject to confirmation that the sale is not prohibited under U.S. Bankruptcy Code, and two, to final confirmation and audit of the status of the loan with the holder of the security deed. Well, who's got the security deed? And that's where we set up here. Said security deed having been last sold, assigned, and transferred to M&T Bank. M&T Bank has the security deed. Therefore, they have something to do with this audit. To final confirmation and audit of the status of the loan with the holder of the security deed. M&T Bayview holds the duly endorsed note. So M&T Bayview, some other entity, has the note, but M&T Bank has the security deed and is the current assignee of the security deed to your property. But they're not holding it. Who's holding it? M&T Bank. Is this just, again, here it says, said security deed having been last sold, assigned, and transferred to M&T Bank. And now they're trying to say that the current assignee of the security deed, but not necessarily the holder, the assignee. The person holding it is M&T Bank. M&T Bayview, acting on behalf of and as necessary in consultation with Federal Home Mortgage Corporation, the current investor on your loan, is the entity with full authority to negotiate, amend, modify all terms of your loan pursuant to something else, yada, yada, yada. Okay, well, they may be able to do that, but I need to talk to M&T Bank to have them do an audit of the status of the loan with the holder of the security deed, which I say is M&T Bank because they said that they are. Said security deed having been last sold, assigned, and transferred to. If it's transferred to somebody, it means they're holding it. It could be assigned to somebody, but they're not necessarily the holder. M&T Bank, so you can contact them, and M&T Bank as attorney in fact for the fictional legal fiction Jeffrey Mathis. So, what I think Jeff needs to do is contact M&T Bank and say, you guys are the holder of the security deed. I need to have the final confirmation and audit of the status. Right? What are the attorney fees that you're wishing to foreclose on? And so this took us to a couple laws that had something to do with those. Right? So let's go take a look at those. First one was 1-11. 1-11. Okay, that's this. The validity and enforcement of obligations to pay attorney's fees upon notes or other evidence of indebtedness. The only thing they're trying to collect on is the attorney's fees. Obligation to pay attorney's fees upon any note or other evidence of indebtedness, in addition to the rate of interest specified therein, shall be valid and enforceable and collectible as part of such debt if such note or other evidence of indebtedness is collected by or through an attorney after maturity, subject to the following provisions. Well, after maturity means, well, the damn thing's matured. There is no more debt. And that's because they take your note and they convert it to a check. Right? They don't keep it as an IOU. They convert it into a bank note. And so it was paid instantly, right? You satisfied by them converting your private note into their private bank note. One step away from being legal tender, but it isn't legal tender yet. It's just called its bank note. but it's payable on demand in legal tender by whoever has it and signs a line where it says pay to the order of on the note. Anyways, they're making that sound like this law, we're only looking at it for one reason, because these people brought it up. 3.1.11. Okay, what is it? Well, it says after maturity, you could be collecting attorney's fees if such note or other evidence of indebtedness provides for attorney fees in some specific percent of the principal and interest owing thereon. Such provision and obligation shall be valid and enforceable, but not in excess of 15% of the principal and interest owing on said note or other evidence of indebtedness. Or if such note or other evidence of indebtedness provides for payments of reasonable attorney fees without specifying any specific amount, such provision shall be construed to mean 15% of the first 500 of principal and interest. Right? Not on all these other things they talked about your debt could be, just the principal and interest owing on such note or other evidence of indebtedness, and 10% of the amount of principal and interest owing thereon in excess of $500. The holder of the note, that would be M&T Bank. No, the note's being held by somebody else. Who was holding the note? I mean, they're all the same people, just using different names, I think. But it's said on here, because all these things are pointed out, so let's just go find it again. Who's holding the note? M&T Bayview holds the duly endorsed note. M&T Bayview is not M&T Bank, it's M&T Bayview. And they have a deal with Freddie Mac. So if you can't get what you want from M&T Bayview, you go to Freddie Mac and complain about it, not to M&T Bank. You may tell M&T Bank, I'm going to go to Fannie Mae, or that'd be Freddie Mac, actually, I believe, Federal Home Loan Mortgage Corporation. But it says they're acting on behalf and as necessary in consultation with. So technically, it's the Federal Home Loan Mortgage Corporation that is holding the note. It's just M&T Bayview is their servicer holding the paper to give that separation. But all this is happening at the head by the Federal Home Loan Mortgage Corporation. And so it's their agents that are committing the crime. Okay, so after maturity, principal and interest owing on such note or other evidence of indebtedness, the holder of the note or other evidence of indebtedness or his or her attorney at law, right, shall after maturity of the obligation notify in writing the maker, endorser, party to be held on said obligation that the provisions relative to payments of attorney fees in addition to principal and interest shall be enforced in such maker, endorser, or party sought to be held on said obligation has 10 days from receipt of such notice to pay the principal and interest without the attorney's fees. If the maker, endorser, party sought to be held on any such obligation shall pay the principal and interest in full before the expiration of such time, then the obligation to pay the attorney's fees shall be void and no court shall enforce the agreement. The refusal of the debtor to accept delivery of notice of specified in this paragraph shall be equivalent to such notice. Excuse me. Obligation to pay attorney's fees contained in security deeds and bills of sale to secure debt shall be subject to this code section where applicable. My, oh my, oh my. Without getting any more difficult, right? It just seems to me like the easy thing to do is go back here and do what it says to do and make some phone calls. Again, they're only doing it for reasonable attorney fees based on the provisions we already read. And to get that information, what they are, well, there would have to be an audit, final confirmation and audit of the status of the loan with the holder of the security deed. So we need to contact this holder of the security deed and tell him you want final confirmation and audit of status of the loan. Who's the holder of the security deed? The security deed having been last sold, assigned, and transferred to M&T Bank. Well, that's these people here, M&T Bank. Now, M&T Bank says they're also acting as the attorney in fact for Jeffrey Mathis, the all caps version. The legal fiction, that name could be a trade name for some other name that's got the man's name, the wife's name, the dog's name, husband and wife, joint tenants, whatever they want to add to that whole line of stuff. And they're saying that's who we're titling it to, that legal fiction. Trade name, Jeffrey Mathis. So, having looked at all that, it's like, well, what are we going to do? So that was one thing to do. Now, the other thing, having looked at this, is when you look at Rubin Lubin, LLC, attorneys and counselors at law, 3145 Avalon Ridge Place, Suite 100, Peachtree Corners, Georgia. Hey, I wonder if they have a business license to do business in the city of Peachtree Corners. We should go check that out. That was kind of the idea. And what did it say? This one ahead. Oh, give me just a second here. All right, so here's about Peachtree Corners. Peachtree Corners pro-business environment, zero millage rate helps ensure businesses thrive. The Gwinnett City is also home to New Startup Incubator, which promotes and supports the entrepreneurial spirit. Blah, blah, blah. The city staff is equipped to assist you and your business with any issues pertaining to services we offer. For permits to licensing and more, for your convenience, you may renew your license online or at City Hall. For questions, contact Business License Department. Thank you again for doing business, City of Peachtree Corners. And Albanese Jackson is the business licensing officer. Well, when you go look at the Muni Code for this city in Chapter 14, it says occupational tax imposed on businesses in the city subject to applicable regulations and requirements. Each person engaged in any business, trade, profession, or occupation of the city, whether within a location in the city or in case of out-of-state business with no location in the state, and fall within the criteria of something or other, shall pay occupational tax for such business, trade, profession, or occupation. Shall. And it goes on to list the different businesses that are in there. And by God, there's one for lawyers. And in the State Bar of Georgia, it says Mr. Peter Lawrence Lubin has a company with that address. Well, so he'd be lying to say that isn't where it is. Does he have a business license? Because if he doesn't, then he's in violation of an ordinance. It's an ordinance violation. And I don't know what it would do, but, I want to make the city do it. Because if the city doesn't enforce that, then the city is in violation of their charter. And then you take it to the mayor and say, Mayor, you're in violation of your charter. You're going to have to declare a state of emergency. If you don't, then I'm going to have to take you to, as we're trying to figure out, which way do we go? That's this idea of figuring out who is in charge of all the property and all the persons in the county. And there's every really good possibility it's the chief judge of the whatever the general jurisdiction court is in the county. The other way is in the, let's call it the county seat city, where all the county buildings are, where all these people are doing their work. Well, they're technically under the jurisdiction of the municipality and its charter. And I didn't mean to do this, but I think we should just take a look because I'm thinking about it now and I do want to show it. So hang on just a second here.
Here's your computer on the day you bought it. And
well, I don't want you. Grand Rapids, RAPM, Michigan, Unicode. All right, so whatever your county seat city is, name, state, Unicode. And hopefully you find something like this. Right, here's the Unicode for Grand Rapids, Michigan. And the first thing it has is, part one is the charter. And when you go to the charter, it will tell you things that you will want to know, like what is the proper name of the frickin' city? It's called the City of Grand Rapids, Michigan. People of the City of Grand Rapids, Michigan, in order to perfect a municipal government which shall ensure economic and efficient administration of city affairs, provide for security, persons, and property, promote the happiness and welfare of its people, conserve and utilize public values, and for public uses, encourage municipal cooperation among cities and the state, preserve the proper use thereof, the privileges of local government subject to Constitution and laws of the state, do ordain and establish this charter for the city of Grand Rapids, Michigan. And you get to Title II, which is officers. Maybe I'll do this here. Yeah. So officers, city officers and departments. You go through this blah, 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 blah. You get to this part where it says the foregoing name commissions, boards. Yeah, it's not going to work. Boards, departments, trustees, and the Board of Education, the Superior Court, the Municipal Court of Grand Rapids, and the Police Court of Grand Rapids, together with their several members, officials, and employees, and other persons elected to serve wherein, blah, 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 blah. That's just said there's 3 courts in Grand Rapids. There's a Superior Court, a Municipal Court of Grand Rapids, and a Police Court of Grand Rapids. And by God, you can't find one of those things in the city of Grand Rapids, yet it's in their charter. And so either they exist and they're not violating their charter, they just need to tell me where they are, or they exist and they're not using them in violation of their charter. And we need to tell the mayor, because the mayor is the guy that can declare a state of emergency. And so this is something we're playing with on the side of this other stuff we're talking about. I don't want to get too deep into this, but this is the other thing I'm working on, that based on, hey, if these guys aren't doing it right, back to our case in hand, if Reuben Lubin LLC doesn't have a license in the city of Peachtree Corners, and he's violating ordinance. Okay, and if he won't get it, well, then he can't, he doesn't have any jurisdiction over you. But regardless of that, get rid of him anyways, because he doesn't have a license. Don't wait till he has one. We should go and check all the cities to see if the attorneys have licenses with the city. And if not, well, then file a complaint with the city that they're violating the charter. And if the city won't do something about it, well, then you're violating your charter. And if you're violating the charter, well, now the mayor has to make a decision because it's his head on the block. He has the power to declare a state of emergency. And if he doesn't, well, then it's time to take him to the chief judge of the county to say, hey, this guy isn't doing what he's supposed to do. Because the chief judge of the county is sitting in a court with gold fringe flags on it. It's a military court. That's an Army flag. It's called the national color. It's not a Navy flag. It's not Admiralty. It's an Army flag. And you're under martial law, martial rule by the cavalry. Right? That's a ground force flag. The Navy doesn't use gold fringe. And so that's why we take it to them and say, hey, this place is supposed to have this charter, and they're not fulfilling their charter. See, at some point we went under martial law, okay? And so the state's been relatively disbanded, but the cities apparently, because they're municipalities, could still function because it does say they can function in the legal code. They just can't pass any new laws, but it doesn't mean they can't enforce the laws that are there. I'd have to go read it closer to say exactly what they can do. My point is, even though the state's defunct, the city, if it had a charter before the state went defunct, where nobody's there anymore, it still has its charter. And so it's the law within its jurisdiction. In fact, Bobby was telling about this yesterday, that, in Pennsylvania, when they set up the first colony there, that whatever was there had the power of the King's Bench, the Exchequer, the Court of Common Pleas, And if you wanted to appeal, you had to get on a boat and go to the king. That was all that was left. That was your last appeal. But all the other levels of court were in the municipality. Well, and that's what this is showing in Grand Rapids, is that there's 3 courts, right? Superior Court, Municipal Court, and the Police Court. It'd be like 3 different levels of court. Excuse me. And then from there to the Supreme Court. Sorry. There to the District of Columbia. I don't know. Anyways. Hey, so that's what's going on with this first one. And give me just a second to reload some papers. Hang on here, Paul. Okay. And so as it turned out, make sure this is going. Yeah, it's going. All right. Another brother just sent me this today, a guy named Morris, who happened to be in Georgia, who had called me before and said he was going to send me some stuff in this foreclosure, and well, it showed up today. So here's another guy in Georgia going through some kind of non-judicial foreclosure through a law, which is someplace in Atlanta, Georgia. So I hope you're paying attention, Morris. Okay, so notice of foreclosure sale, note and deed, secured held by Lakeview, note and deed to secure debt. Note and deed to secure debt held by Lakeview Loan Servicing, LLC. They have the paper. Originally made by Morris Stills to Mortgage Electronic Registration System as nominee for somebody else, blah, 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 the amount, where it is, property address, our file number. Okay, so there's their file number. So you're going to want a copy of that file because you are a real party in interest. And this is what his said, right? This is written, not nearly the way that, well, not written quite the same as the one we just looked at. This law firm has been retained to start foreclosure proceedings against referenced property immediately. Enclosed is a copy of notice of sale submitted by publisher, so forth and so on, some courthouse. As a result of your default under the terms of security deed, you are hereby notified the entire amount of the outstanding principal balance, interest, and other authorized charges, which would be the attorney's fees, have been declared and is now immediately due and payable in full. So the question is there, if there's no outstanding principal balance and there's no interest, well, then all there would be possibly is attorney's fees. And this is why we have to have that audit. The note executed in connection with the loan allows for additional attorney fees to the debt in the event the collection by or through an attorney at law. Pursuant to official code, which is the one we read, you are hereby afforded 10 days from receipt of this letter to pay in full the debt allowed without having to pay reasonable attorney fees. After 10 days, all attorney fees allowed under applicable Georgia law may be added to the debt. In the event the above referenced default is not cured and the property is sold at foreclosure to a party other than the creditor holder, there could be money for the sale for distribution to the lien holders in the property and or to the former owner of record. Oh, they could foreclose on you and there could be money left to distribute to you because all they're going to do is sell the property to pay the debt that apparently you're not willing to pay. And then whatever's left is supposed to go to you, the former owner of record. To determine whether our firm is in possession of any money or distribution to lien holders or former owner of record, please call something or other. Now, the problem is the owner of record isn't necessarily you in your full legal name. It's that legal fiction because they never transferred the property properly. Anyways, whatever it is, though, it's in this file, right? You want to have a copy of the file. You don't want to ask a question. I want a copy of file 16-010171 because I am a real party in interest. And by the way, do you have a license to do business in the city of Atlanta? Lakeview Loan Servicing is the holder of the security deed to the above referenced property. And we saw from the other one, you need to go to the guy with the security deed to ask for the audit. The entity who has full authority to negotiate, amend, or modify the terms of the loan is Senlar FSB. Whoever that is. Well, that's got 2 pages. To discuss possible alternatives to foreclosure, if you'd attempt to bring your loan current, please call Seller FSB at whatever. Should you need additional information about this foreclosure, you can call this number. Under certain circumstances and conditions, a lender may be able to allow you to reinstate the loan and stop the foreclosure. Should you desire to reinstate the loan, please contact this office. We will assist you in determining whether reinvestment is allowed and, if allowed, the amount of money which must be paid. All payments made through our office must be in the form of certified funds. In the event you have received a discharge in bankruptcy, that discharge may extinguish any personal liability you have had for this loan. In such event, any action taken would be limited to the foreclosure of the above referenced property and would not be an attempt to collect this debt personally. If you are involved in an active bankruptcy case and no relief from automatic stay has been attained by your lender, please email your bankruptcy information immediately to somebody else. Be governed accordingly. Well, there's 2 different versions. And all I can say is this guy here needs to give an audit. Lakeview Loan Servicing LLC is holder of the security deed. And why is that? Well, it's because. Let's go back to, who's that brother? Jeff. Just so we get the words right, what to ask for from the holder of the note. Or the security deed, right? Because that's what this said. Holder of the security deed. Yep. The sale will be conducted subject to confirmation sale is not prohibited under U.S. Bankruptcy Code and final confirmation and audit of the status of the loan with the holder of the security deed. You're going to want to contact the holder of the security deed and say you need final confirmation and audit of the status of the loan. Right? Just write it down right now. I'm asking for final confirmation and audit of the status of the loan. I'm just saying, I think that's what our brother here needs to do. Morris, there you go, right? Ask him for the final confirmation and status of the loan. What words were they? Final confirmation and audit of the status of the loan. Okay, so there's two versions of in one state of a non-judicial foreclosure. So look at your paperwork closer and see what they're foreclosing on. Because this one made it quite clear. They're just foreclosing on relative to payment of attorney's fees. Okay, I'm going to stop again for a second. Give me just a second here. Okay, so where are we? Well, now we just talked about non-judicial foreclosure based on case in Georgia, 2 cases. And now about what the judge said. And this has to do with sending letters to the chief judge and pointing things out in the courtroom. And so before we go to that, just because I need to ask again, in case you didn't write down the first time, if you can, please donate. Just stop the screen right now, figure out if you can do one of those ways, and please help a brother out. We're getting close. So this has to do with a gentleman out in Colorado, right? And what we're looking at here is a sworn statement that would be used. He was going to try to send it to the CVB. I did a video on that, right? So this is all things I talked about in the video before. Now this isn't what he sent, right? But what he did is copied and pasted and put it on here because he was going to send it to these people next. What he did do is he sent a letter to the chief judge of the U.S. District Court for Colorado that had these words on it. And so, forgetting this, too, this is the part that would have changed. In case 13 CR 00442-CRM is a violation of civil liberties protected by the Bill of Rights. That's what this is about. Interesting thing is, a friend of mine has access to Pacer, and he went and put that number into Pacer, and nothing shows up. So I need to make sure he gave me the number proper, right? But he does have a court case going on, and I'm sure that's the right number. Because what they had said is they had sealed his letter. So the wording that we're seeing here, right, in the letter form sent to the chief judge ends up in the hands of the judge of his case, and well, now the case isn't there. So before I read the letter, let me tell the story, because most of it's about me reading what this says. But the story is, this letter he sent on Friday, right? He got a green card receipt, I guess must have been on Saturday, saying they got it on Friday, because on Monday he's going to go to court. He's going to court because he wants to fire his attorney. He had already put in a motion to fire his attorney. So this was all prior to him putting this letter in. And he hadn't even talked to his attorney. But he shows up to court on Monday, and he's sitting outside the courtroom, and the attorney that he had hired, that now he wants to fire, walks up all, hey, how you doing, brother? Da-da-da, all good. He says, hey, what about this? What about the letter? And, well, it caught this gentleman on off guard, because he had just put it in. It's like, well, how does this guy know I put a letter in, right? But so they went into the hearing, and the hearing is really just to fire the attorney. And the judge is kind of miffed that she's, he's saying she's acting like she's really miffed because she has to be there for this. But she asked the guy, well, do you want to go pro se? And he said no. And at the end of the day, she wouldn't let him fire his attorney. And his attorney says, well, Judge, what about the letter? He says, well, it had personal information on it, so I've sealed it. And then they left, And now his attorneys, all sorts of wanting to help him out, where he wants to file a motion to basically get the case dismissed. Could have said discharged even. I need to get that verified. But this is an IRS case for a guy who had done an OID. Actually, he didn't do an OID. There was an OID done for him by an enrolled agent. Somebody else we've talked about in the past. That's supposed to be the highest credentialed person in the highest credentialed office or credentialed person from the IRS as an enrolled agent. And so that, now they want to dump it on that person. But up until now, they wanted to make our hero a co-conspirator with this enrolled agent. Now, the interesting thing is, whatever the enrolled agent did got money put into this guy's account, right? So they did send the money to him, and then they took it. Well, I say, well, if none of this ever happened, they'll put the money back in his account, because apparently it was his. Unless the IRS is going to swear, unless the commissioner or the IRS is going to swear under oath that it's not our hero's property, then they should return his property to him. But anyways, let's read the letter. So in some case, 13 CR 00442 CRM. Those are the judge's initials at the end, right? So that's who had the case to start with, at least. Violation of federal rules of criminal procedure. Rule 42, criminal contempt of court, use of color of law in violation of civil rights, professional misconduct. False personation and simulation of legal process. Kenneth N. Hammond and John F. Walsh are participating in an unauthorized practice of law. These names are not the legal names found on the roll of members of the Colorado Supreme Court Office of Attorney Regulation Counsel. However, see here they call that the roll of attorneys. A little bit easier for me. However, Kenneth Mark Harmon and John F. Walsh III are licensed and both are committing professional misconduct, contempt of court, acts of treason, and countless other human right violations. Legal instruments require licensed names, 5.5, given under oath. No pseudonyms. That's really good. You got the rule, 5.5. Legal instruments require licensed names, rule 5.5. That rule 5.5 would be the same in every state, right? All these professional rules of professional conduct for attorneys, they use the same numbers. So I need to go look at mine again. That's good. Very, very good. Federal government sui juris legal personality is the United States. Now, I have to disagree just a little bit. I believe it's the United States of America because that's what it's called in the Articles of Confederation. The style of the Confederacy shall be the United States of America. But I certainly agree it's not United States of America because United States of America is a jurisdiction of King George III and his successors. And that nation and the nation, the United States of America, have a contract called the Constitution. And that's the union of those two nations sharing the same territory. It was worked out in a peace treaty. I think that's what they did. I can't really prove it, but I'm just going to say that's one way. I just know United States of America is not the United States of America. So whatever. As per Federal Court of Claims, any prosecution for... Okay, so apparently the Federal Court of Claims says it's the United States. So if it does, it does. I'd like to see where it says that. Any prosecution for a crime against the United States must always be prosecuted in this name. Case number whatever is a simulated legal process and could be construed as an act of treason because the plaintiff is the United States of America. But that's not the government. So you're really not in a federal court being charged with a federal crime because the government isn't the plaintiff. Right? I think the plaintiff needs to be the United States of America, not United States of America. Or it needs to be the United States, but not United States of America. And that's who the plaintiff is. And if you look at federal paperwork, at the top it says in the U.S. District Court, Western District of Michigan, or whatever it is, right? There is no court named in the. And when you read the rules, it says you put the name of the court at the top of the paper. Well, then they're not using the legal name of the court, and so it's not a legal document. If I need to be legal, so do they. And that's why we're pointing out to the judge that, hey, what's happening in your courtroom is not legal. It's a simulated legal process and could be construed as an act of treason. Throw it in there. Indictment must concise and definite statement. On or about occurs several times and is not a definite statement. That's very true. In an indictment, it can't be on or about. It has to be on the day. Daryl Brent Geisking is a legal fiction and not the living spiritual man, Daryl Brent Geisking, as per the birth certificate. Daryl Brent Geisking is not being sued in his proper persona in violation of his civil rights. Daryl Brent Geisking, sui juris. The arrest warrant return was left blank, no signature made by a peace officer. Proof of the arrest warrant was not sworn to me nor revealed verbally at the time of my arrest or before I was jailed. I first saw the arrest warrant 5 weeks after the initial arrest. While in my public defender's office, I was jailed without charges and without seeing a magistrate judge for 3 days, clearly a violation of my civil rights. False impersonation comes with a liability. The indictment mandates that the court seal must be used. The indictment mandates that the court seal must be used to seal a lawful document, yet there is no evidence of a court seal being used here. No seal equals no evidence, evidence not conclusive. Other errors and omissions on the indictment, arrest warrant, criminal complaint are too numerous to mention here, but are symptoms of a simulated legal process through color of law. A true bill requires an endorsement by a grand jury foreman. Endorsements go on the back of the document. If this signature is the back of the document, then where is the front? Hey, I've said that before myself. Yeah, endorsements go on the back. That's what an endorsement is. It goes on the back. Clearly, an omission. Why is my copy different? I don't have it, therefore it's a misprison. Criminal complaint oath gives my DBA name, birth in 1958. The real spiritual man is 1949. Officers of the court appear to be violating the Constitution of the United States and Labor Code martial law, and I ask for an investigation and disciplinary proceedings against wayward officers of the court and an equitable remedy for the wrong done to me by these officers of the court. Take judicial notice within the courtroom over which the chief judge of the district court exercises superintending control flies the national color, that would be the gold fringe flag, in accordance with AR 840-10-23. This flag symbolizes said courtroom as a military courtroom and the United States Army's duty to defend my person from false accusers and rebels. I am prepared to submit this complaint to the Army if it falls on deaf ears, which is why it's on this document. And then he went on to go with a personal note where he told what he had done and that he had used an enrolled agent, and he paid the enrolled agent, had no intent to commit a crime. The enrolled agent is an expert and filled out the IRS forms. I had no idea it could be wrong. Well, of course. It's an enrolled agent. I thought all was legal and was confirmed when the IRS wired the money into my account. So there's what I'm saying. If they wired the money in your account and they're not willing to swear that it isn't yours, then they need to put it back. And he went on and on and on. But what he said at the end is, again, when I moved, I was not charged with any laws broken. I had written letters to the IRS offering restitution and asking if I had broken any laws, but never received a response. When addressing my public defender on these issues, his response was, "That's the way we do things around here. It's all corrupt." Those were his words exactly. And I believe that's exactly why when Bobby went today to find 13 CR 00442 CRM, he said he couldn't find it with Pacer. I don't have Pacer. I can't look. If somebody else knows a way to look, please do. But for sure, the letter that was sent to the chief judge, that went to the judge over the case, that points out the violation of his civil liberties. The judge said that it's been put under seal. Now, that could mean under seal to keep it from the public. It could also mean under seal of the court of record as evidence that the man submitted into the proper court because he went to the chief judge. He didn't go in the court. He went to the chief administrator of the district court, United States District Court, District of Colorado, or whatever the proper name is. So, anyways, and then so Daryl was told that by his attorney, and as the attorney was talking to the judge in the courtroom, that in March is when they could put in a motion, right? And so the guy wants to put a motion in and hang it on the enrolled agent, who's probably doing it properly. So it's like, well, I don't want that to happen either. So I got to get a hold of Daryl and say, we need to get something to this enrolled agent and have her do the same thing. She didn't break the law. What needs to happen is not for a motion to be put in a court case, because then you're agreeing that the court case has validity. We need to say, no, it's a simulated legal process, and you go to the prosecutor and tell the prosecutor to make this go away, or you, my attorney, who are now committed to me, are going to file a criminal complaint against the prosecutor for a simulated legal process. And put the public defender, right? Split the house. Devil's house can't stand when you split it. The prosecutor and the public defender are working for the same people. And now we're going to split their house. And, whatever happens to them happens. Hey, you don't play the game. Because I plan on, as soon as Jesus gives me the rod of iron, I'm going to smack me a clay pot just as hard as I can. I'm not going to miss. And that's what this is all about. You guys want to keep playing games. Eventually, God's going to give us the iron rod, and we're going to crack some clay pots. Amen. Okay, I got one more to share with you. Give me just a second. Okay, continuing on. Here a little bit ago, John in Virginia wrote a letter to the Chief Judge of the 10th Judicial Circuit of Virginia, Leslie M. Osborne, complaining about this, that, and the other thing in his particular case where he's done a little jail time. This is a travel issue, traveling without a driver's license. And he submitted a letter. So 2 days before he was supposed to have a hearing, he took the letter and he went down to this court here, right, to the 10th Judicial Circuit, where the court hearing is actually in a different county. He went to the county where the 10th Judicial Circuit is and went to the window and told the clerk, can you give this to the judge, to Judge Osborne? And she looked at it and said, well, I can put it in his box over there, and his secretary will come down and get it, and he'll get it. And said, well, you're sure he'll get it? So, yeah, he'll get it. So, okay. So, John didn't mail it. Right? He did personal service. Basically, here, you've been served. Right? He didn't mail it. He didn't do anything else other than take it and say, put this in the judge's box for me. And well, he didn't say that. I'm just saying now, tell him to put it in the judge's box for you. Because apparently the secretary comes down to the clerk's office to get mail or whatever's in the judge's box. All that to say, 2 days later, he has a hearing. And while I actually have the transcript of the hearing, I don't have his permission to use it, but he'll tell you that it was, different than had been done before in different hearings, because this is his first hearing in this matter. It's like his appeal time now. And so when he got there, he went to the window in the county and asked if this letter had been filed in his case yet. And they looked and it hadn't. And they said, well, here, this is what it looks like, and gave it to the lady. And she went in the back for a little bit and came back. And, well, I guess it'll show up here eventually. We haven't seen it yet, yada, yada, yada. And then John went into his court case. And and the judge was treating him different than before. And I really like to read the letter or read the transcript sometime. But beyond all that, that was 2 days after he had given the letter to Leslie. Well, on the 17th, because this is written on the 10th, on the 17th it actually got put into the court case. And it came with this cover letter. See that staple right there? Because his letter is stapled to the back of this. And it was to the Honorable Epps, Clerk, Prince Edward County Circuit Court, regarding John Risner Lehman, CR 16348. How do you say that? At sec? Which means, there's numerous court cases that have been created based on one number. I think in the one that I did, and when I showed the video and the case dismissed administratively, there was at least 4 or 5 different court case numbers for the same frickin' thing. Well, there were 4. I won't say there were 5. There were 4. 4 different court case numbers. Anyways, dear Ms. Epps, please find and close the letter dated January 10th, 2017, received from John Risner of the Heritage Layman, which is how he wanted to be addressed, and that's how he did it. Please file this in the criminal case file. I will take no action at this time. Sincerely yours, Scribble, Leslie M. Osborne, Judge. Filed in the clerk's office out of the Circuit Court of whatever NTY, and that's what I want to know. What does NTY mean? Of Prince Edward County, CC. They have plenty of room for these letters. It's not like they don't have the letters. And if they're afraid to use letters, they write shit all the time. But how come they filed in the clerk's office of the Circuit Court of the NTY of Prince Edward County, CC? What is CC? Circuit Court, I guess. And this says something Circuit Court, Prince Edwards County. And so basically, this seal is for a county court, a local jurisdiction court, not for a court of the state, which I believe that this one is. Right? The 10th Judicial Circuit of Virginia is the state, and this is the, where did it say 10th? It must have been on something else. Well, they use the numbers 10. Well, actually, it's when you go look at these places online, right? They don't use 10th written out. They use 10th, 10th, right? Different court. It's that simple. It could be a different court. That's all I got to do. Well, it's not the same name. No, it's not the same. It's not exactly the same. So it's different. But whatever they did, they put this into John's case. And in this case, one of the things John had done was sent a agreement or an offer in compromise to the prosecutor's office. And so this letter wasn't brought up in the court case, in the hearing, but they brought up this agreement that John had sent to the prosecutor's office that the prosecutor had never responded to. And so John was saying, well, they never responded, that therefore they agree. And the judge made a point to point out, well, not in my court, that doesn't work, blah, 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 blah. But he did say, however, I'm paraphrasing now, you could have this enforced, you got to file a motion. File a motion to enforce the agreement. Is what I think the judge was saying. That was out of one side of his mouth. Out the other side, however, you could go do this for motions for your trial instead. Right? And so it's like you got A or B. But what they were doing was ensuring that they were giving John some type of remedy or relief so that they couldn't say that his civil liberties were being violated in the courtroom. I guess that's what I'm trying to get at. They were being very, very careful with John. Just didn't know what to do at the time, right? Because all this is brand new. So we'll see what's going to happen next. But this is the letter. Please file this in the criminal case file. I will take no action at this time. They did not pay attention to it. They put it in the fucking criminal case file. So they did pay attention to it. They did not pay attention to it, which means they paid attention to it. Right? Because you're not guilty, you are guilty. Case closed. Leave. Right? That's how they can get rid of stuff. They just do a double knot. I was told it was not that I was not correct. They just weren't inclined to issue a warrant, which means I was correct. But they didn't want to issue that warrant. And but here's the letter, at least the words that John used. I don't believe he'd have a problem sharing this. It's very good. So claim, trespass, violation of Bill of Rights protections. Greeting, Leslie. It has come to my attention that you sometimes act as Chief Judge of the 10th Judicial Circuit of Virginia, but at all times you are a man. I, as a man, whose true Christian name is John Risser, am made in the image of Almighty God and heir to the throne of King of Kings, Jesus Christ. Amen. One of the peculiar people of God, Christian, a peaceable inhabitant of the Virginia Republic. I proclaim a treaty of peace to every man and accept the peace of every man. I challenge the jurisdiction of this court. I am not a U.S. citizen or a resident of Virginia. Further, I do not consent to a sham proceeding contrary to due process of law of the land. I am not a legal person. I am not a civilian. No presumption of court have been explained. No presumptions of the court have been explained. I lack the capacity to act as a defendant. I hold no surname. I do not understand any foreign language. Because that's what they're using in court. It's a foreign language. They're using the same words we do. They're just using different meanings. So it's a foreign language. That's why you need an interpreter. It is my belief I am a victim of a simulated legal process by individuals under your immediate administrative control that use color of law as part of a scheme to coerce my consent to the extortion of my private property. Tell them what you feel and allege voluntary servitude of my person. This type of activity is wrong and has led to the generation of case numbers. You've got a whole shitload of them, and many others, which led to these. And then he started listing some things. The full legal name of the court is concealed, as is the nature of the court. No seal of the court of record is evident. Alleged officers of the court represent themselves by pseudonyms instead of their full legal names. Alleged legal documents they submit have omissions and errors that simulate legal process and have the effect to obstruct justice. The instruments uttered to me by alleged officers of the court and their witnesses are written into languages contrary to law, due process violation, foreign American Sign Language or Dog Latin as debased Latin as well as English. Two men acting as law enforcement officers threaten me with violence and imprisonment if I continue to exercise my God-given liberties protected by the Bill of Rights. One man acting as a law enforcement officer arrested me using a defective warrant. One man acting as a magistrate using a defective warrant which was not signed by a sitting judge and had no affidavit attached ordered I be taken to jail against my wish, where I remained for nearly 4 days. Examples included our exhibits A, B, C, D, E, and F. This lack of use of court seals evidence habeas corpus has been suspended and the country is under martial law, or that insurgents have usurped the office of civil authorities or engaged in war crimes. Bingo! In violation of Labor Code martial law and Constitution of the United States civil protections, your subordinates are using the court you have superintending control over and their civil office for private gain in violation of their appointment and oath of office. Alternatively, their behavior could be construed as that of belligerence in an ongoing rebellion. Your agents are harassing and harming me. I have harmed no man. Leslie M. Osborne, acting as Chief Judge, I demand an investigation into this wrongdoing, the restoration of my good name, the prosecution of wrongdoers. If you will not act to protect my liberties and close this matter, I will take this matter to the Inspector General of the United States Army and His Holiness Pope Francis I. May you be blessed as you do the Creator's will, expressly reserving all liberties. I say here that I verify in open court and herein to be true. All right, so there's the words that Johnny used on a letter, just written to the Chief Judge. Right. The only thing I didn't put on here, I guess I forgot to copy the heading that for the Chief Judge. And boom, got put in a court case. Boom, the court's acting different. Boom, the judge said, well, if you want to have that agreement enforced, you need to file a motion. That's still stuff being done in court, and I guess it could be, right? But the Bible says the widow kept going to the chief judge until he dealt with her adversaries. So that's the option too. Go to the chief judge, say, hey, they're still coming after me. How come this is still going on? I told you it's a simulated legal process. These people aren't using their proper name, blah, 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 blah. Right? What they don't want to ever have to do is prove that they're not following the fucking law. So they're trying to find any way to get the thing dismissed, discharged, something, so that the court case can still show that it was valid. And what I want to do is crack their clay pot for bringing fraud upon the court. And whether that just means they take their bar card and, whatever, I don't really care. I don't want anybody to go to prison forever. I just want them to stop. I don't hate anybody, right? Amen, Lord, I forgive. I forgive every man. But they're going to stop. Okay, hey, one more just because I can. And you've been here this long. I'll give you another dose. Hang on a second. Okay, and I don't know if Stephen has done this yet, but he had a problem, and had to do with police criminal complaint. This is the Commonwealth of Pennsylvania versus, and then they had his name here. I believe it was in all caps, first name, middle name, last name, with an address down here. It did have a district number, had the person's name, the address, telephone number. Obviously, I'm just trying not to show, try to keep people's personal business out of it, but you got to have something to look at, right? And so I'm looking at this form, and it comes down to defendant identification information. So forget everything else in the form. Now we're down to the defendant identification information. And there's no name. Right? There's no name in this box. I know it says AKA, but that doesn't mean anything. Right? They got to cross it out. This is the defendant identification information. If it isn't in here, you haven't identified the defendant, and there's no name in there for him. So, and then they check, and they come down here, and this is traffic ticket stuff. I officer somebody, right? It says name of the offendant. Well, your name doesn't have officer in it, so that's already incorrect. But officer somebody with some number, some city, so like Greenville Police Department, and whatever their ORI number is, which I need to look at more closely because that's some kind of number that's tied into all these agencies. They all have their own ORI number. And that ORI number would tell you what their proper name is. Because one of the things I pointed out, we'll see when I look, that when I went to look up the name of the city police department, it wasn't Greenville Police Department. It would have been Greenville City Police Department. That's the proper name. They didn't use the proper name of the agency. And then, blah, 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 with violating the penal laws of the Commonwealth of Pennsylvania. Right? So, whatever the penal laws were, they never really said, right? Penal laws could be like the common law. So, that was the first page. And then, let's see what another page looks like. I'll just show you the kind of stuff they throw in these things as they're lining you up. So we come to another page, got some more stuff in. Turning movements required. And in all these, they say the actor, and then they had the uppercase name, right? The actor, on or about in the county of something, drove a vehicle, namely whatever it is, on a highway, namely whatever it is, and turned the vehicle or moved from one lane to the other, or entered traffic stream on parked position either without reasonable safety or without giving appropriate signal in a manner provided in the section, namely, defendant failed to signal making a left turn from some street onto state route something or other in violation of something. Blah, 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 blah. Yeah, he did that. And then he did this. He operated, namely, something was not covered by financial responsibility. I guess that would be insurance. Registration certificate, some more. Tick, 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 tick. As they're ticking up the dollars. You get to the last page. Forgetting everything else is said. I ask that a warrant of arrest or summons be issued and the defendant be required to answer the charges I have made. I verify the facts set forth in the complaint are true and correct, best of my knowledge or information and belief. Verification is made subject to penalties of Section 4904 of the Criminal Code relating to unsworn falsification to authorities. Right. Relating to unsworn falsification, which means you didn't swear to anything to an authority. We're talking about unsworn falsification to authorities. This complaint is comprised of the preceding pages 1 through 4. The acts committed by the accused, as listed and hereafter, were against the peace and dignity of the Commonwealth of Pennsylvania. There's that common law freaking catch-all, right? The peace and dignity. You disturbed the peace. And a conservator of the peace, who in Michigan they say all circuit judges are conservators of the peace, they have a duty to maintain the peace. So, were against the peace and dignity of the Commonwealth of Pennsylvania and were contrary to acts of the Assembly or violation of the statute cited. Before a warrant of arrest can be issued, an affidavit of probable cause must be completed, sworn before and issued before the issuing authority and attached. Blah, 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 blah. And now on this date, I certify that the complaint has been properly completed and verified. An affidavit of probable cause must be completed before a warrant can be issued. So that was the blah, blah, blah that, they got him with. And so what I did is I wrote him a letter. And this was the idea for this one, right? All of these are meant to go to the chief judge, or here they call it the president judge, right? But to whoever it is of the county. But as I'm thinking, okay, well, we saw that you can send one to the chief judge of the U.S. District Court, and it will get down to the judge of the court that you're dealing with. So that's the option. The other one might be, as I showed in John's, that the 10th Judicial District is actually over numerous counties. So in Michigan, we have, that would be like the appeals court in Michigan, where there's an appeals court. There's like 4 appeals court. They split the state into 4 pieces, and that's what they had done back when they set up the thing in the first place under federal law. They split it into 4 districts, and first there were 3, I believe, and then there were 4. And each of those districts had judges that rode a circuit. And so that's really how the Court of Appeals is set up in Michigan right now. So I might send a copy to that guy, the chief judge, whoever it is, over the section that's over, I'm in Grand Rapids, so whatever that ends up being. Nevertheless. So in this case, the United States of America. Why? Well, because the United States of America is the Confederacy that was established under the Articles of Confederation. The style of the Confederacy shall be the United States of America. XREL, your full legal name, Robert Allen Retluski, Relator. I would be the relator for the United States of America, bringing a claim to the Commonwealth of Pennsylvania, President Judge of the Magisterial District, however they do their numbering. Right? But you're always on top of the paper. You're the letterhead. So I, Robert Allen Rutluski, relator, claim that case number, whatever it is, other cases incorporated by reference, is a violation of international law of war and civil liberties protected by the Constitution of the United States, from which the relator demands relief. Police criminal complaint number refers to a legal fiction, all caps, as an actor, and never identifies the accused by the full legal name, right? Your full legal name, in violation of Bill of Rights, Fourth Amendment protections of persons, and Fifth Amendment protections of due process, right? In the Fourth, you're supposed to be secure in your persons, papers, and effects, right? And if they're taking you out of your full legal name, then they just took you out of your proper person. You're not secure. Complaint, defendant identification information, is void of any name. There's no name in the defendant identification information section of the paperwork. City Police Department, Greenville Police Department, is found on the police criminal complaint, is not the full legal name, which would be Greenville City Police Department, and its use on any legal proceeding document is a violation of the Commerce Clause of the Constitution and a color law violation, right? Because anything they're doing is illegal. They're trying to do this as a traffic violation in commerce. Well, if you don't use your proper name, we can't contract, and you're violating the Commerce Clause of the Constitution. The gold fringe flag in the room I have and am now being coerced into appearing is either a symbol that I am in a military tribunal, or I am at a military tribunal, or it's a war trophy of foreign insurgents, either of which is an indicative of the law of war having been invoked and these proceedings a war crime. Because they're not following the fucking law. They're committing the crime, right? It's not you. It's never about you. They're not doing it right. You don't have to answer for anything until they do it right. President George Washington signed into law on June 1st, 1789, the oath of office that satisfies the 6th article of the Constitution of the United States, common copy attached, commonly known as 1 Stat 23. So if you Google 1 Stat 23, you can find a copy of it on the House.gov website. And you need the first 2 pages, and in there it says this is the oath that satisfies the 6th article of the Constitution. It's the first law of the first Congress of the United States. You can't go any further back into the laws of America other than the Constitution. And so the very first thing outside of the Constitution they have people do incorrectly, so they cannot hold a constitutional office. It's called the rule of law, right? You violated the rule of law. You didn't follow the rule, you don't get the law. If you didn't follow the rule, because the law says it's the duty of the person taking the oath to make sure that whatever needs to be done gets done, if they don't do that, they don't have any constitutional authority. Unless individuals have filed certification of having been administered said oath of office, then those individuals have no constitutional authority to enforce any law in the United States. Any claim to the contrary is an act of treason. I do not believe my accuser or his co-conspirators have filed any evidence that they have complied with the Constitution of the United States and are by default warring with the Constitution until proof and evidence to the contrary is submitted for inspection. Commonwealth of Pennsylvania law makes it a duty of the president judge to see to my relief. That would be in Title 234, Rules of Criminal Procedure, Rule 116, General Supervisory Power of President Judges, that says the president judge shall be responsible for ensuring the judicial district is in compliance with the Pennsylvania Rules of Criminal Procedure, other rules, statutes applicable to minor judiciary courts, clerks, courts, and court administrators. I demand the president judge investigate my claim of violation of civil liberties and unalienable rights in this matter and see to my relief and equitable remedy. Executed, whatever date it is, full legal name, son of God, put your address, phone number, email, tell them who you are, where you live. Don't be shy. And so I don't know if he's going to do it or not, but that's what I came up with a scenario like that. And so there's other people want me to look at theirs, and I'm going to try to get to it. But I wanted to share this so I could say that I had, and now I'm going to shut her down and move on to something different for a bit. But if you can, please do donate. PayPal is ashleyritluski@gmail.com. Walmart or Myers, Greenville, Michigan. You could send me something, money transfer, or, hey, through the mail. Robert Ritluski, 10955 14 Mile Road Northeast, Rockford, Michigan, 49341. You all have a great day. We'll see you.